As respondents urged that I was supposedly required by the doctrine of laches to file a lawsuit under 204B.44 with this court during the election campaign of 2012 or 2010, rather than simply engage in the core freedoms of political association speech in my campaign, and that the election contest, which is governed by a clear statute of limitations, should not be available. I believe the election and related judicial scheme established by the legislature is designed to avoid forcing candidates or voters to take these kinds of issues to court during a campaign. By making the elections voidable for deliberate, serious, and material violations of election laws, the legislature gave notice to even the most privileged candidates that their interests and ambitions do not rise above the people's constitutionally protected interest in elections that fairly and freely express our will, and that the courts will have the power to void such flawed elections. But before the Minnesota Supreme Court adopts the dangerous view that Minnesota law required me to bring a suit to this court during the campaign to get a judicial remedy, consider that had I initiated such a suit during the 2012 campaign, which respondents also urged would have been meritless, I could have been attacked politically by Democrats or Republicans so that my vote total might have fallen below 5%. That would have been one election failing to meet the 5% threshold for minor parties. If the same thing happened in 2014, or if it had happened in 2010, when I admit I was aware of the so-called inclusion bylaw, the quotas of the DFL, and then again in 2012, 2 consecutive elections, if that had happened, the Minnesota Independence Party would no longer be allowed on the federal ballot in the following election, as I understand it. So we have 2 consecutive elections where you fail to meet the minor party threshold and your party is out. Thus, this court is bound to care for the legal rights of the Independence Party as a minor party and the legal significance of the requirements of minor party status. This is a big deal for me, and I hope the IP. Now, McCollum's share was higher than she achieved against Republican Teresa Collette in 2010. It was a tough race. She got 62% of the vote. But a crucial set of facts was conceded by the DFL. Their responses show that they feel they can maintain a system of quotas. McCollum and the DFL admit their goal is to skew the endorsement process by regulating participation by suspect classification. Ritchie gives the nod to this practice and does not contest that he is charged by state law with enforcing it as a principle of the DFL Constitution. They call this a principle. And also that they can suppress email communications with arbitrary and capricious decisions and actions intended to make it difficult for minor parties to have an even playing field in a fair and free election, while they handpick the next member of Congress from CD4, or even a United States Senator, according to an unconstitutional quota system that corrupts the endorsement process, not only at the precinct caucus level, but all the way up to the DFL State Convention, as set out in the petition. And in a footnote here, I note that the order of Justice Gildea understates the claim by appearing to limit it to only the precinct caucus. The DFL Constitution bylaws state that this quota must be done at every level, quote unquote, and outreach and affirmative steps for inclusion, which they call this, shall be explained at the precinct caucuses in any higher level conventions, and shall be included in the DFL call to convention. And further, that these affirmative steps shall be the basis for challenge to officers and delegations, so they can unseat a delegation that doesn't get chosen by these rules. Now, these are the facts that Congress needs to hear, and this court needs to consider. They and this court need to hear of quotas by race and sex for delegates in choosing representatives of the color, and determine if this is the way Congress wants to choose its members from Minnesota. If it is, then any or all of the 50 states could expect to have such procedures for the Democrat Party. The results of such practices will be devastating, and there will not be just 50% women in Congress, but 90%, because none of the respondents deny that all the decisions of the Democratic Party are made by the majority of women. Democratic women rule. But the DFL responds in its submission, we have the power. You're not one of us. We don't associate with you. And you have to just take it as an eligible voter and politician. This is said by McCollum, by the DFL party, and Ritchie. And they assert that even though they submit their DFL constitution and changes therein to the secretary, they submit it to the secretary, and he is charged with preventing those who disagree with the quotas from participating and voting, that he is merely a filer. He doesn't enforce. There is no state role or action in the state's election scheme for Congress that requires them to comply with the United States for Minnesota constitutions, as I've set out in footnote 10. Now, their very arguments say that they intend to skew the issues of a certain ideological manner. They argue, for instance, that if they drop those rules, those ideologies would be challenged. And this is a footnote. On page 3, the DFL argues that, as the Supreme Court has recognized, the inclusion of persons unaffiliated with a political party may seriously distort its collective decision-making, thus impairing the party's essential functions, and that political parties may accordingly protect themselves, quote, from intrusion by those with adverse political principles, unquote. And out of that footnote 9. But who's to say that I have adverse political principles to the DFL voters? When is the last time the DFL expressed themselves without the protective prism of gender and race quotas? And I say in footnote 10 that I would argue that the twisted way in which the DFL and state law operate and apply the participation statute, who may participate and vote, is unconstitutional as applied under the 1st and 14th Amendment. And also the Minnesota Constitution, Article 7, elective franchise, every person shall be entitled to vote in that precinct, and Article 1, Bill of Rights, Section 1, the people in whom all political power is inherent, together with the right to alter, modify, or reform government whenever required by the public good. And 2, Section 2, no member of this state shall be disenfranchised or deprived by any of the rights or privileges secured to any citizen thereof, including the voting right. So out of footnote 10. The law is enforced and applied unconstitutionally limits the participation of white men and, of course, others who voted Democrat in the last election or intend to in the next. And none of the DFL respondents have shown that they tell DFL voters that they are being manipulated in deciding who is to be put before them. Of course, we all know about backroom decisions. This is just a new face on backroom cigar smoking decisions. Instead, they smoke Virginia Slims.